Do you know why Burger King is known as Hungry Jack's in Australia? Ego or error? Stay tuned for more of the story. Hi everyone, and welcome back to Elise Explains IP, the podcast where we make intellectual property make sense. Today we're diving into one of my favourite real-world intellectual property stories. It involves one of the most recognisable fast food brands on the planet, Burger King, and what happened when they tried to expand into Australia and discovered they couldn't legally use their own name. This isn't just a cute bit of trivia. It's a perfect case study of how trademarks actually work in practice and why brand strategy isn't just marketing, it's legal infrastructure. By the early 1970s, Burger King was already a major US brand. They had strong recognition, a proven franchise model, and a menu that travelled well internationally. International expansion was a great idea. Australia was the next logical step. But when the company looked at launching here, they immediately hit a legal roadblock most difficult. The name Burger King was already registered as a trademark in Australia by another business. And that meant that the American brand could not legally trade under its own name. This is where many business owners misunderstand trademarks. They assume that fame travels with them. It doesn't. Trademark rights, as we've discussed before, are jurisdiction specific. They exist country by country. Registration in one market does not create any rights in another. Burger King's Australian expansion partner was an entrepreneur named Jack Cowan. He still really wanted to bring the business to Australia, but without the name, the whole expansion risked collapsing. So, Burger King gave him a list of alternative brand names that the company and the parent company had previously registered internationally, but never really used. One of those names was Hungry Jack, a pancake brand, and Jack Cowan, being a little egotistical, wanted to make the brand his own, so made it possessive. Hungry Jack's. It was available, it was registrable, and most importantly, it was legally safe. So, that's the name Australia got. From a business perspective, this is fascinating. Nothing operational changed. Same cooking methods, same menu items, same franchise model, but the brand identity was almost entirely different. Sure, they look similar perhaps from the outside, but they've got a very different feel. And here's the insight. Consumers don't buy companies, they buy brands. So Hungry Jack's had to build recognition from scratch in Australia, even though the underlying business model was already proven elsewhere. And that's an expensive and slow way to do it. And that's exactly the kind of risk trademark planning is meant to avoid. Let's unpack the intellectual property lessons here, because there are several that matter for real businesses. Number one, trademarks are a territorial asset. As we've discussed, a trademark is not a global right. It's a bundle of national rights. Every country you operate in requires its own protection strategy. This matters especially for startups planning overseas expansion, e-commerce brands selling cross-border, tech companies entering new markets, professional service firms considering franchising internationally. If your name isn't protected in the destination market, you may not be able to own it there. Number two, priority often goes to whoever files first. Trademark law in many countries operates on a first-to-file basis. This means the first person who registers it generally wins, regardless of who used it elsewhere. Even massive global brands can lose priority if they delay filing, and that's exactly what happened here. Number three, brand availability should be checked before expansion plans are announced. One of the most expensive makes businesses can make is assuming they can fix the legal side later. But brand clearance should happen before entering a new country, before signing franchise agreements, before launching marketing campaigns, before printing packaging, before building a website. Because once money is invested in a name, changing it becomes exponentially harder. And the story doesn't end with the name choice. Years later, the relationship between Burger King's US parent company and the Australian franchisee had deteriorated. There were disputes over expansion rights, contract performance, and strategic control of the Australian market. The parent company tried to establish the Burger King brand directly in Australia. Of course, litigation followed. Franchise agreements were tested, and ultimately, Hungry Jack's retained its position as the operating brand in Australia. So even today, Australians don't go to Burger King domestically. We go to Hungry Jack's. And many people don't even realise that the connection between the two brands. You might be thinking, that's a multinational fast food chain. How does this apply to me? But the same risk applies at every scale. I see versions of this issue all the time with online retailers who are launching internationally, software companies, consultants who are exporting packages overseas, Australian brands expanding into the US or Asia. They assume that their brands can travel with them. And legally, they don't. And if fixing it later can mean a lot of expensive litigation costs, forced rebranding, lost momentum, customer confusion, and sometimes complete loss of the original name. So, what should you do instead? Here's a simple framework that I give clients. Firstly, decide where you are realistically going to expand in the next 3 to 5 years. Second, run clearance searches on those jurisdictions early. You can do a free search on the global brand database. It doesn't cover everything, but it's a good start. Thirdly, file trademarks proactively, not reactively. Fourth, align your brand rollout with your filing timeline, because trademarks are not just defensive tools. They form part of your growth infrastructure. They determine whether your brand can scale smoothly or hit avoidable legal walls. If there's one lesson from today's story, it's this. Trademark planning isn't about protecting your past. It's about enabling your future. Burger King didn't lose its brand globally, but in Australia, it lost the ability to use its own name. And that shaped decades of branding, marketing, and legal strategy, all because of timing and territorial rights. So, the next time you drive past a Hungry Jack's, remember, you're looking at one of the clearest real-world examples of how trademarks shape business strategy. Same burgers, same flame grills, different name. All because of intellectual property law. And thanks for listening to Elise Explains IP, where we turn legal lessons into practical business strategy. If you know someone expanding their business internationally, feel free to share this episode with them. Like and subscribe for more. Because sometimes the biggest growth risk isn't competition. It's whether you legally own your name where you're going next. And if you're considering an international expansion yourself, you can book a free strategy call with me through my website, and let's have a chat about it. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.